Kids are not entitled to be a beneficiary. Hi, Jeff Marsachi, the Plain English Attorney, and today we're going to react to a Reddit thread on r/estate planning, and it's about a son whose mom is on her deathbed, and there's no plan. Okay. This, unfortunately, is an all too common occurrence where people have absolutely no planning in place, or they kind of ad hoc, well, I threw these people on the beneficiary designation 15 years ago when I opened the account, didn't stay on top of it, and now it's like, oh, I may only have a few weeks to live. Oh gosh, I guess I better do something. All right, so let's just kind of jump into it, get a little bit of a background of the situation and the advice that the community gives, as well as what I would recommend. All right, my mom is on her deathbed but doesn't have a will. What can I do? My mom, who is my only parent, is on her deathbed. I'm her only child, 26 years old. She's in a domestic partnership but not married. Her partner and my grandmother both agree that her assets should go to me, so I'm not concerned about them trying to take anything. All right. This, unfortunately, may be a very hard lesson if it does happen. There's nothing like death and money on the table to make people go a little crazy. So people may have the best of intentions now, or they may just be saying it while the person is alive, but then once they pass on, forget it. All bets are off, and they just kind of go for the jugular. It happens way too many times. However, I'm confused about the process of probate and whether it's too late to construct a last-minute will or try to do power of attorney. She's made me her beneficiary for her life insurance, but not for her bank accounts, and I'm not sure about her 401k/stocks or Social Security. Her partner said that she doesn't have any debts, but she spent a week at the hospital last week. She has good health insurance, but I'm unsure of how much coverage that provides for hospital bills. All right, so there is a potential for debt here. So that also kind of has to be taken into consideration when putting together whatever the plan's going to be. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. I'm panicking a bit because she's about to pass, of course, and because she didn't have everything set up ahead of time. She has terminal cancer, but began deteriorating very quickly the last few weeks. Right now, she spends most of her time sleeping, but when she wakes, she's aware of what's going on. She doesn't have any confusion or anything, but she's very weak and fatigued. I live in Florida, if that helps. I was also wondering if it's legal to withdraw the money from her bank account with her permission by sending it to my account virtually. I found out I'm not the beneficiary of that account, but she intended for me to be. She made me beneficiary of it before it was purchased by another bank. This is also a cautionary tale that I bring up with my clients. Usually it's when we're doing an annual review meeting or after we set everything up. We've got the quote, the big blue binder if they're doing a revocable living trust. Make sure you always keep copies of those beneficiary forms when they're filled out. I've had several clients over the years who started out with one bank, had everything set up. The bank gets bought out, and then that bank got bought out. And by the time they pass on, it's already 2 bank purchases removed. Oh, well, we don't have any of that other paperwork from before, so we're just going to throw everything into probate, which could be a disaster if it's not the correct beneficiary, aside from the fact that it's going into probate and now has to go through that meat grinder. So first piece of advice, I understand you're in a confused panic, and that's very true. This not only happens when somebody passes on or before they pass on, but also just after it. And people just start wanting to run around and do stuff. And it's like, wait a minute, you just kind of need a plan. But just sticking to the legal issues. If your mother is mentally competent, it's not too late to make a will or a power of attorney. You could withdraw money from her account with her express authorization. Very careful there and very true. But you can't use that to shortchange any creditors. That includes the hospital, doctors, Medicaid, or other government aid programs. Also, tax authorities, credit card companies, or anybody else she owes money to. That is a big thing. You can't just say, well, I'm just going to withdraw the money and then bury it in the backyard, and then we're not going to have to give it to creditors or Medicaid or anything else. Ha, ha, ha. We withdrew the money before she died. Does not work. And in fact, you can probably get into some legal trouble if you try it. Even when she passes without a will, you could apply to the probate court for authorization to handle her estate, including paying off the creditors. But this is much easier and less expensive if there is a valid will nominating you as the estate personal representative. In fact, it's so much better that I would recommend paying for a lawyer to draw up a will now. Most experienced estate lawyers have done deathbed wills before. It's not new to them. A lot of companies, hospital, etc., will not or / should not talk to you about how much is owned to who, how much is owed to who, unless you can show them court authorization. The bank might stop your attempt to transfer the money, but that doesn't make your attempt illegal. All right, so that's actually some potentially solid advice. Again, it's not the best planning ahead thing to do, but it could get the job done. One thing that I would add, and honestly, I don't remember if there's more about this from some other people, get the grandmother and the partner to sign off on it in addition to mom signing this is what she wants to do, even if it's just a kind of handwritten note. So if there ever is question, nope, see right here. Maybe even go as far as to do it in front of a notary. If she can sign a will, do it now. It will speed up the probate process by months. I guess that really depends on where you are and what the jurisdiction is, if something like that will speed it up. In North Carolina, doesn't usually delay or not delay any amount of time if there isn't a will versus there is a will. In fact, the process is almost identical except for the identification of who's going to be in charge. So maybe there's several weeks when the person's applying, there isn't a will. Okay, we just need to make sure there's nobody, quote, of closer relation who might be there. I wouldn't say months, but weeks in North Carolina. Other jurisdictions, it might be a huge difference, and you don't want to mess with that if you don't have to. A will alone does not prevent an estate from having to go through the probate process with the court. Very true. A much better tool at this point in time would be the power of attorney so that you can add yourself as the transfer on death / payable on death beneficiary to all of her assets. However, time is of the essence since a POA document typically ceases at death. You will want to make sure the attorney drafting the POA specifically stated the authority to add or change TOD/POD beneficiary designations to her accounts. This includes banking, investments, retirement accounts, life insurance, real estate, although you need an attorney to draft a deed for any real estate. If all you do is get a will signed, nothing really changes, since by law you are the only legal heir anyway. To avoid probate, all the assets that are in her name only will need to be below the probate threshold, which I believe is $75,000. Again, this is Florida. The quickest way to make an asset non-probate is to add a joint owner with the right of survivorship or a beneficiary. Estates are a complex matter, though, so your best bet is a quick consultation with an experienced estate attorney to discuss your goals. Very, very true. Here's a technical thing, and it's going to come up in the next comment. You have to fill out forms. If it's as the power of attorney, and it very explicitly states that you're allowed to change the beneficiaries, then this 26-year-old person can go into the bank and on behalf of mom, make the changes to the beneficiary designations and put them on. If they don't go that route, they just do the will. It means probate. Well, the third alternative is, oh, well, we've got to put this paperwork together and bring it to mom to sign. That doesn't always work. In fact, I've had financial institutions say, here's the forms they need to sign, and here's, they flag the little places where they need to sign, bring it to the person, they sign it on their deathbed, send it off to the bank. A week later, they're dead, and then we contact the bank, and they go, oh, well, it was the wrong form. You're going to have to go to probate. But you gave me the form. You gave me the form, and you flagged where things needed to be signed. Oh, well, so nothing we can do. Okay. Just so OP is aware, the original poster, many of the bigger banks will want for you to use their own POA forms. That's true. That's becoming more and more true each year. OP's mother will need to request them. A general POA which OP provides may not be accepted. Banks want the one their own lawyers drafted up. In my experience, smaller banks will take a POA that you provide, but there may be some back and forth before it's accepted, as the bank will want their lawyers to review and approve it. And in either case, it'll need to be notarized. And that's just general, depending on where you are. The formalities for a power of attorney are going to vary from state to state. North Carolina, it's got to be in writing, signed, and notarized. Don't need witnesses for a durable general power of attorney. Other states may also require 2 witnesses. In fact, North Carolina requires 2 witnesses who are not related to the person signing it for a healthcare power of attorney, but not for the financial one. All right. You really need to talk to an estate attorney. If she dies without a will, you might be the only heir of hers, but the fact that she has a partner tells me there might be a common law marriage question. If she is lucid and alert, I agree with Exton guy above. A deathbed will is best. That's another whole thing. If you're married, there may be other rights that the spouse gets. And if you aren't married, but there is a partner and they've lived together, when the state statute says, oh, that's it, you're common law married, that's it. They end up getting the rights. So they may not, it may not be all of it, but depending on the state, it could be that they end up being the beneficiary of anything that ends up in probate. So avoiding probate is definitely a plus, but at the very least, if you have a will saying, yes, everything goes to my child, you might be getting not necessarily everything, but hopefully most of it. Again, depends on state law. A spouse is the only person, and I'm going out on a limb here, so please, if I'm wrong, correct me and put it into the comments if there's any lawyers watching this. The only person who is ever, quote, entitled to be a beneficiary, and it's up to whatever the amount is a spouse. Kids are not entitled to be a beneficiary if their parent wants to write a will leaving everything to charity or someone else. So again, having the will is a good idea if you have to. Very sorry to hear about your situation. I too am in Florida. I'm in South Florida by Fort Lauderdale. Have you spoken to an attorney? I would be happy to put you in touch with one to pick his or her brain. Let me know. And if we don't connect, try making some moves while she is still lucid. Very true, because this capacity doesn't last forever. Now, there's other videos I'm probably going to do on what is necessary for testamentary capacity, and I can talk about that pretty well in North Carolina. The issue has come up many times over the years with some of my clients. Oh, well, mom's getting forgetful. She can't sign a will. Well, no, not really. If she knows who she is, what she has, and where she wants it to go, that's enough for testamentary capacity. She can explain that. It doesn't matter that she forgot what she had for breakfast. All right. So really the best thing is plan ahead. Don't wait until you're on your deathbed and say, oh, okay, everybody start to run around and try to do stuff to minimize the damage. That's like, okay, your car is absolutely falling apart, and it's like, yeah, that engine's gonna fall out. Better get some duct tape. No. All right, so I hope you found that information useful and entertaining. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.